Janice Luft?
Yes, Your Honor. Yeah, I'm here.
Okay. All right. And what's the claim in this case, counsel?
Your Honor, this is a termination of tenancy, or not a termination of tenancy, sorry. This is just it is termination of tenancy. There's no lease in this case, no rent paid. We gave a 30-day notice to quit. And Ms. Luft has not left the residence as of this point.
Right out of the gate, this case already feels way more emotional than the average landlord-tenant dispute. On paper, this sounds simple. No lease, no rent payments, a 30-day notice to quit, and the homeowner wants the property back. That's the clean legal version. But courtroom veterans know something important. The moment someone starts saying, "It's not that simple," the tension level instantly changes, and that is exactly where this hearing is headed. Judge Simpson immediately zeroes in on procedure instead of emotion. Notice how he asks about proof of service almost instantly. That matters because eviction courts run on paperwork and timelines. If the service process is defective, the entire case can slow down or collapse regardless of the personal conflict behind it. That's the legal reality most people outside courtrooms never realize. Meanwhile, you can already feel the collision coming between two completely different narratives. The attorney is framing this as a straightforward possession case, but Miss Luft is clearly preparing to tell a much deeper story involving caregiving, years of labor, personal sacrifice, and alleged harm. And when those emotional layers start entering a courtroom designed for narrow legal questions, things can spiral fast. This is the kind of hearing where one side wants efficiency and the other side wants to finally be heard. That combination almost always creates courtroom fireworks.
When was the okay? What was filed in this case? I don't have a proof of service of the notice to quit. When was that served?
The notice to quit was served March 14th.
Okay. I need a proof of service on that because I have the tenant copy. I don't have the service copy of it in my file. Ms. Luft, what's your position on this?
Your Honor, I have
Yes.
with Mrs. Humeski since February of 2017. I have acted as a personal assistant, a caretaker for the home and property, and also a caregiver. She's a retired professor from University of Michigan. She taught Russian and Ukrainian for 45 years. The house was full of 45 years of teaching materials of hers and her husband's. Mr. Humeski taught at EMU. In 2017, Roman Humeski, Rick, her oldest son, in front of me told her that when she passed away, anything that was left in the house would be put in a dumpster. So for 6 years, I helped her to clear out her teaching materials. I think the city records will show that that recycling bin and trash bin was filled every week to the max, and the weights were heavy. I also helped her during COVID to gather up all of her articles and papers and to send them to the archives in Ukraine. She was born in Kharkiv, Ukraine. So going through this last part of her life was difficult with the news about Ukraine. There were a lot of complicated jobs I did for her, beginning with a cleaning of her home.
Okay, but ma'am.
Now the hearing is shifting from legal procedure into emotional narrative territory, and you can already see Judge Simpson trying to keep control of the lane. Miss Luft is laying out years of caregiving, organizing academic archives, cleaning the home, and helping an elderly professor through the final stage of her life. From her perspective, this is not just some place she stayed. She's trying to establish value, loyalty, sacrifice, and emotional investment. But here's the courtroom disconnect. Eviction court usually focuses on possession, occupancy status, notices, and compliance, not the entire history of a relationship. That's why the judge keeps interrupting and trying to narrow the issue. He's basically saying, I hear your story, but what legally answers the eviction question? Then things suddenly escalate again when she starts talking about radon poisoning, injuries, wage theft, and assault allegations. At that moment, you can practically feel the courtroom energy change. The case is no longer emotionally contained. It's expanding in every direction at once. And here's the big question for viewers. When someone feels deeply wronged outside the narrow legal issue being discussed, can they realistically separate emotion from procedure inside a courtroom? Because that tension is driving everything happening here.
What is
So
that going
there's
to
money
have?
that is owed me. I have been injured.
Okay,
The
so
house-
here's what,
recently, Your Honor, the
Oh.
house was,
ma'am,
I've been poisoned. I've been poisoned. The house
here's
was
what I'm gonna do.
radon on
Do you-
all 3 floors. Every room was full of radon. The whole.
Ma'am, please.
Yes, sir. I'm sorry. I've been injured.
Are you going to have an attorney represent you on this?
Yes, this
To
is not
file a
tenancy
counterclaim.
case. There's wage theft. And even this process of them trying to push me out is more wage theft. I need time. I've looked for apartments. I need a job. I need some medical care. I've lost 25 pounds from radon poisoning. And their family did nothing about it, just ignored it. I was assaulted in her backyard while I was working and helping her to go outside and meet friends on her birthday last year. And a friend of hers grabbed my wrist and crushed it and jerked my arm. to the ground.
Ma'am,
Yes, sir.
ma'am. I am not here right now
Where are
to
you?
try this case.
Okay, I'm telling you, I want to be out. And I don't want an eviction on my record. That's not fair.
Okay, ma'am,
And I-
then how much time have you talked to them about leaving?
We're not on speaking terms anymore.
Okay.
Your-
That's
Your Honor.
Joyce.
Unfortunately, I can offer a date of August 1st. This is when the rents start, the apartment rents start. I can find a job in that time. They owe me money. I don't see where there should be a problem. The attorney for the.
Okay, ma'am,
Yes,
please.
sir. Yes, sir.
This is one of those moments where frustration completely overtakes strategy. Miss Luft is trying to argue fairness, unpaid labor, health problems, and financial hardship all at the same time, but the court keeps pulling the discussion back toward one narrow issue: vacating the property. Notice something important here. Judge Simpson is not necessarily rejecting her emotions. He's rejecting the expansion of the hearing. There's a major difference. Courts are extremely structured environments, and once a hearing starts drifting into unrelated grievances, judges often step in aggressively to regain control. That repeated "Mom, please" isn't random. It's the judge trying to stop the hearing from becoming unmanageable. The attorney also makes a strategic move by emphasizing that none of these issues are directly related to the eviction itself. That's a classic courtroom tactic. Isolate the legal question, shrink the battlefield, and prevent the hearing from turning into a broad emotional dispute. But from the defendant's perspective, this probably feels impossible to separate. Imagine believing you were exploited, injured, ignored, and discarded, then being told the court only wants to discuss whether you should leave the house. That emotional disconnect is exactly why this hearing feels so combustible.
Your Honor, she had been instructed to contact my office. Not once has she done so. All of the issues that she
Okay, all right.
raising
So
is
you
not
guys,
related to the
aren't,
eviction.
okay, look, so you guys aren't talking to each other. I guess that's why everybody's here.
Well, United
So-
Way is the solution, I thought. If we could use
So
United Way
apparently
to
it doesn't
finish up
matter.
our tax paperwork and the final payments to me. And she paid into United Way for 45 years. I've talked to them. They're willing.
So what
to do
about
this.
I'm not trying this case today? Did that mean to anybody?
Okay, I'm sorry, sir. I need more time to prepare the move.
Okay,
I'm traumatized. I've been injured.
really, I am not hard of hearing. I heard you.
Okay, I'm sorry.
Counsel, will
Yes, Your
you
Honor.
give her till August 1st to vacate the premises?
No, Your Honor.
Okay, then here's what's gonna happen. I'm gonna give her time to get an attorney. Ma'am, how much time do you need to get an attorney? It looks like she has counterclaims that she could raise. How much time do you need to get an attorney?
A week to interview. attorneys to pick one.
All right, well, the problem is that I'm not here next week because of a judicial conference, so this matter will be adjourned to May 26th, 2026, or May 26th, 2023. At what time?
10 a.m.
At 10 a.m. I would want it to be the 26th, but anyway. And I will indicate defendant to file an answer by the 23rd.
All right.
By May 23rd. All right, so get yourself an attorney, come back. Counsel, you need to file the proper proof of service on the notice to quit.
Yes, Your
Thank
Honor.
you.
Thank you.
Thank you. You're
Judge Simpson just did something very important here. He slowed the case down instead of forcing an immediate outcome. That matters. The plaintiff wanted movement. The defendant wanted time. And the judge essentially split the difference by granting an adjournment and opening the door for legal representation. Legally, this is significant for two reasons. First, the judge recognized potential counterclaims. He specifically mentions that Miss Luft appears to have issues she may legally raise, which means the court is acknowledging this situation may be more complicated than a standard removal action. Second, the proof of service issue still matters. Judges take notice defects seriously because due process is foundational in eviction proceedings. But emotionally, the biggest moment here may be the tone shift. Earlier, the courtroom felt chaotic, emotional, and constantly interruptive. By the end of this segment, Judge Simpson has restored structure. Deadlines are established. Expectations are clear. Both sides are being told exactly what must happen next. And then, almost instantly, the courtroom pivots into a completely different case involving bond arguments and criminal history. That transition alone shows how relentless courtroom dockets really are. One emotionally loaded dispute ends, and another high-stakes situation begins immediately.
Public Defender Ashley Bashir here with and on behalf of Mr. Barrage Ante Scott.
Right, Scott. All right, what are we doing?
We are seeking to adjourn on both matters. And also we would like to address bond.
Purpose of the adjournment? I don't have the grade for.
Our understanding is that there is currently no misdemeanor offer in this case, and we are seeking to advise our client on next steps. Oh, I said no, there's no misdemeanor offer. Yes, that's what I said. Sorry. Yeah.
February 20th, 2025. As a bond.
Yes. As to bond, Mr. Ante Scott has been in custody for 16 days. He does have a place to return to. It appears that this is the only matter holding him. He's also willing to go on a GPS tether in order to comply with conditions. He's appeared for, there's been one hearing combined previous to this hearing for both cases, and he has appeared at that hearing. He was out of custody at the time. So we would argue that he is not a flight risk and not a danger to community, and we'd request a PR bond.
Response from the people.
And I think your work Mr. Scott's history probably is once as a criminal history that goes back several decades, multiple felony convictions, misdemeanor convictions, whether or not you have a history here off the top of the head. In his history, I certainly have concerns like.
Well, and I don't know whether or not this defendant can, I have grave doubts as to whether or not he would be able to comply with any bond conditions that the court gives him. I've been through this time and time again with him, giving him a chance, letting him out. Next thing I know, he's violated the bond conditions. He's back in, pleads with me. I would let him go. We put more conditions on him, trying to let him out, and he just doesn't comply.
This second hearing has a completely different energy from the eviction case. Here, Judge Simpson is no longer dealing with emotional housing disputes. He's evaluating risk, compliance, and credibility. And you can tell almost immediately that history is dominating the judge's thinking. The defense is making the standard release argument, stable residence, willingness to comply with GPS tether conditions, previous appearances in court, and claims that the defendant is not a flight risk. But then the prosecution brings up something devastating in bond hearings, repeated non-compliance. And watch how Judge Simpson responds. He's not focused on whether the defendant might flee forever. He's focused on whether the defendant will follow court orders consistently. That distinction is huge. A judge can believe someone isn't dangerous in the traditional sense and still deny release if they think conditions will be ignored. When Judge Simpson says he has grave doubts, that's the warning sign right there. Judges usually choose those words carefully. He's basically telling the courtroom that prior opportunities matter more than present promises. And honestly, this is where a lot of defendants struggle in court. Every new hearing becomes connected to the memory of previous chances. Once credibility weakens, rebuilding it becomes incredibly difficult.
And that's a concern for the court. I think ultimately we would find a flight risk like he's going to flee the jurisdiction, I doubt it. Flight risk that he may not come back and we got to go get him, real likely.
All right. Thank you, Your Honor.
Bond will be then denying the motion. Bond will continue. Thank you.
Thank you.
Can I say something? Sorry, please, God, I don't ever get to talk to you all the time. But I was just gonna say, like, it's kind of crazy because like the trespassing that I do have today, I do have a PR bond.
Sorry, let's go.
I do have a PR bond on that, and I am released on tether and Romulus. That I have a PR bond on that case, and they have released me the day on the 27th. I had a writ that I had to go to Romulus for another case, but I have a PR bond on that, release the tether. I would really ask for this chance for opportunity to be free one more time, because like I did come to court and I will come to court. It's not like I won't come to court, and I want to have a chance to be with my family. My mom got cancer. Like, I know you haven't heard none. I was supposed to get my tooth fixed on the 30th, like we talked about. I couldn't get my tooth fixed because I'm in here. I had a seizure when I first came in here, and didn't nobody, take care of me like they supposed to.
This is the emotional core of the hearing right here. Mr. Scott is no longer arguing legal technicalities. He's pleading for human consideration. He talks about his mother's cancer, his health issues, his family, his birthday, his desire to change, and the fear of staying incarcerated. And whether people agree with him or not, you can hear genuine desperation in his voice. But the courtroom problem is this. Judges hear promises constantly. Every bond hearing is filled with people saying, "I'll do better, I've changed," or "just give me one more chance." So for Judge Simpson, the question isn't whether the speech sounds emotional. The question is whether the defendant's history supports the claim. That's why this exchange becomes so tense. Mr. Scott is speaking from emotion and urgency. Judge Simpson is responding from pattern recognition and prior experience. Those two perspectives are colliding head-on. And viewers should really think about this. At what point should a courtroom prioritize a person's stated desire to change over their documented history? That balance between mercy and accountability is one of the hardest parts of criminal courtrooms, and you can see it unfolding live right here.
I would really like an opportunity to be free and really have this PR bond. I will come to court and I won't violate. I did come to court. I did make it to all my court dates. You know what I'm saying? I'm not a flight risk, and I would like an opportunity to be free, Your Honor. And if it's anything that you can put conditions on, I will follow them. I just did a year. I don't want to do it again. I changed my life. My birthday was January 20th. I just turned 37. So I know what I'm looking at. I know what everybody has looked at me and want me to change. It's time for me to change my life. It's not a matter of playing with nobody's life and playing with the judges or playing with the prosecutors or none of that. I would like an opportunity to show you that I can change my life without being incarcerated, because it's not helping me.
Mr.
I would like.
Mr. Scott, how many times forget the other judges because they've got their own thing. Have you and I been through the same thing?
Yes, Your Honor, but
How many times do you think it is?
no, what I'm actually saying is like, this could be an opportunity for you to see me to do better in life instead of doing what I
Like
used to
the
do.
last three times.
I changed.
Last three times were an opportunity for me to see that too.
No, but I'm saying that I changed my life since then. I had changed my birthday's January 20th, sir. And I had changed my life since then. I don't want to keep doing
Raj, I'll take a look at it for the next time you get here, but I'm keeping what I said.
I mean, if
Motion
it's,
for introductions
I mean,
tonight.
but
And if you want to keep talking, I may not consider it the next time you get here.
I understand. I was just trying to
Mr. Scott, we can address it later.
say something. That's all. I mean, I know you're not gonna change your mind, but it was just, I had to say it on record. And like I said, this is not a place that I would want to be. I changed my life since then. I don't want to keep coming here. I don't want to see y'all like this. I definitely don't want to see nobody to judge me, because people are judging me about my past record, and it's not fair. I can't pay bond because I don't have the money, and like, I'm on disability. That's the only money I get. With me being in here, they can cut my Social Security off, and I have to wait another year to get it on. You know what I'm saying? I'm not gonna be able to. My grandma's not gonna put no food in here for me. There ain't no way I can get anything that I need. No calls or see how my family doing. My mom, like I said, my mom got breast cancer, and she just lost all her hair. She got that cancer where you lose all your hair. I don't want to have nobody die in here, and I cannot talk to them no more. That's all I'm saying. Like, if my mom dies, my dad already dead.
Mr.
You
Scott.
know what I'm saying? Like, my sister
Scott.
died 2 years ago. Like,
Mr. Scott,
yes, sir.
I have heard you. I have made my ruling. I'm done.
All right. That's fine. That's right.
By the end of this hearing, the emotional exhaustion in the courtroom is impossible to ignore. Mr. Scott keeps returning to the same core message. He believes people are defining him entirely by his past. He talks about family loss, financial hardship, disability income, fear of incarceration, and wanting an opportunity to prove he has changed. But Judge Simpson ultimately stays firm on the ruling. And that's the final takeaway from this case. Courtroom decisions are rarely based on emotion alone. Judges may listen carefully, may acknowledge hardship, and may even sympathize privately, but rulings often come down to documented patterns, prior compliance, and legal risk assessment. Judge Simpson made it very clear that repeated bond violations carried more weight than present assurances. Meanwhile, the earlier eviction hearing showed another reality of court. Emotional history does not always fit neatly into narrow legal proceedings. Both hearings today revolved around people trying desperately to explain the full context of their lives, while the court focused on specific legal questions. That contrast is what made this entire session so intense to watch. Real people, real consequences, and judges forced to make decisions inside strict procedural boundaries. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.